so glad you could come because this is a very special program. First of all, we're doing a whole hour on two subjects that loom larger daily. One is the First Amendment to the Constitution, and two is the Civil Rights Act. I should say Civil Rights Acts, because there are several, and we will not discuss each of them, but we will discuss the fact that there are several, because that can be problematic. Anyway, I'd like to welcome you and our guests, Professor David Achtenberg and Professor Alan Rostron. Both of them are lawyers and professors in the University of Missouri at Kansas City School of Law. And Professor Achtenberg especially is the First Amendment to the Constitution. And Professor Rostron is going to be the spokesperson for the, oh, you're in civil rights, David.
Say, probably
David Achtenberg is civil rights. You'd think I could get that straight, wouldn't you? David Achtenberg is the civil rights expert, and Professor Rostron is going to talk about the First Amendment to the Constitution. You know what I didn't realize, and I've tried to kind of shuffle things in together, so because what I didn't realize was that, first of all, the times have changed in the writing of the civil rights amendments, the civil rights laws, and I honestly have to confess, I didn't know that the first Civil Rights Act was in 1866, and that's a long time. And the First Amendment to the Constitution, I probably would have known had I focused on it, but the First Amendment to the Constitution was adopted December the 15th, 1791. Now that's a long time for an amendment to be viable. I want to read you the First Amendment. It's very short because the contents of it are, everybody says, well, that's my First Amendment right. So we'll see what the rights are. It says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. That's it. Now, it occurs to me that it's the interpretation of that First Amendment that causes us difficulty. Would I be correct in saying that?
Yes, I think so. It as you said, it's a relatively short provision, but it's chocked full of a lot of pretty important concepts.
Oh, very.
It's dense. I mean, you got, freedom of religion, both the Establishment Clause and the free exercise aspects of it, and then all the speech and press and other sorts of expression rights that are included in there as well. So, and then each of these concepts, it's not like there are some parts of the Constitution that don't require a lot of interpretation, like if it says the president needs to be 35 years old, sort of means what it says. It's fairly self-evident, but none of those provisions in the First Amendment are particularly obvious about how far they would go.
Well, and it isn't, the parameters are not there.
Right. All it says, I mean, now, once in a while there have been members of the Supreme Court, for example, Hugo Black was the most famous of this, who at least attempted to not interpret it, to just read it in the most literal possible way, to say, and read literally, it's stated in a pretty absolute way, right? It says Congress shall make no law, taking away people's freedom of speech, for example. But very few people would say there's no circumstances whatsoever under which speech could be limited.
Yeah, yeah. Well, and I must point out to both of you, and I, jump right in here, David, that times have changed slightly since 1791. Yeah. And there is much more to contend with. Life is much more complicated than it was then. So the interpretation of that First Amendment does cause some angst on the part of numbers of people on both sides, all sides of the issue. But it occurs to me that in talking about the First Amendment and the Civil Rights Law, there is some overlap there. Often within the Civil Rights haves and have-nots, do's and don'ts, there are appearing First Amendment rights.
Sure.
Is that
Now, one of the acts from the 1800s, the 1871 Civil Rights Act, usually just called Section 1983, it's the law that people use if they believe that their First Amendment rights have been violated. So, for example, when the school in Missouri thought that its First Amendment rights had been violated because it wasn't given equal access to a program for resurfacing its playground.
Mm-hmm. Oh, I remember that. Yeah.
That action could have been brought under Section 1983, one of the Civil Rights Acts.
And they did get permission, didn't they, to resurface that playground finally?
Yeah, they did get government assistance to resurface that playground.
Yeah, the government assistance was withdrawn because, wasn't that the?
Well, this was a case in which the state of Missouri had a program to provide surfacing from scrap tires, and it had sort of a combined goal. Let's recycle the scrap tires instead of having to put them into landfills, and let's use them for something useful. And what could be more useful than a children's playground? Put soft stuff so they're not landing on gravel. The difficulty was that one of the applicants who appeared to be qualified for this, and it was a selective program, was a daycare center that was run and owned by a church. And Missouri initially took the position that under its constitution, this was providing money or services to a sectarian organization, and that was not permitted under the Missouri Constitution. The church challenged that and said that the federal free exercise clause of the First Amendment required that they be given an opportunity to apply. And if they qualified, and they did qualify under the other criteria, to receive the assistance.
Very interesting. And it doesn't, you know what I find extremely interesting? Resurfacing a playground in and of itself doesn't seem like a major issue. Just do it, you know? And I guess it points up some of the difficulty in today's world, Alan, that people are so litigious about everything that even resurfacing a playground on a religious school causes.
Well, I think it shows how these rights are in tension with one another often. You know, you could say, well, I believe in, let's say you take the position, I believe strongly in religious freedom. Well, that could mean different things here. It could mean that you believe that the people who are running this daycare are entitled to religious freedom and that they shouldn't be excluded from a government program just because they have a religious orientation to the way they run their preschool. But on the other hand, you could say, no, I mean that I believe in religious freedom in the sense that I don't want the government involved with religion. I want the stricter separation, the wall between church and state. So I don't want the government giving scrap tire, funding or materials or whatever to a religiously oriented institution. So it's true with the religious parts of the First Amendment, and certainly with freedom of speech and that sort of thing. All these rights, they sometimes are in tension with one another or in conflict, or at least there are trade-offs in the virtues of protecting them more strongly or less strongly.
And this conflict between the Establishment Clause and the Free Exercise Clause and the freedom of religion part of the First Amendment also sort of points to the line drawing problems. A playground seems like such an innocent start, and it is, of course. Yeah. Everybody wants kids to land on something soft instead of gravel. Yeah. As simple as that. This is quite properly a daycare center that has a religious goal. As I think you know my sister-in-law who runs the Beth Shalom preschool, and hers also has religious goal. And the playground and what happens on the playground is part of that. And the difficulty is if we decide, as the Supreme Court did, that it's okay to provide assistance to build a portion of the playground, then the next question is it okay to provide assistance to build a portion of the sanctuary? And then it becomes pews,
It
stained
grows
glass
like
windows, you know.
Yeah, it does.
And so it,
Yeah, it
these are not easy issues.
No, it isn't. And I'm thinking to myself, even King Solomon would have a hard time today because there are intended and unintended consequences of every law or amendment or whatever that's made to the laws. And we can't always anticipate what those are. And sometimes they just cause an awful lot of difficulty, sometimes necessary, sometimes unnecessary.
Religion's such a big part of society, and so it's inevitably you're going to have issues like this. I remember in the arguments about this case and the briefing and that sort of thing, one of the examples used was that everyone could pretty much agree that it's okay, for example, for the police or for the fire department to provide emergency services to a religious institution. If there's a church, that has a fire or something, the government's allowed to go
that. Yeah.
and respond to it. And so it's sort of a whole spectrum, as David said. Then, but if you step from that and say, well, if they can send the police and the fire department, why can't they help with the safety of the playground? But then, eventually,
Or the safety of the building.
Yeah, exactly. Yeah, what could they provide in terms of the building? And then eventually you get to the point of issues about the, paying the teachers and the textbooks. And Supreme Court's had to decide so many cases about that over the years,
Oh,
about
man. That's
buses for the students to get to school, or the textbooks, or the teachers, and at some point you cross the line where it starts to get into the more religious aspects of what they're doing.
There's one question I want to ask about the Civil Rights Act so that we could clarify. Does the Civil Rights Act extend, does it have global applications? Because there are so many businesses that are American businesses that operate overseas. How does the Civil Rights Act operate in those conditions?
Let's start with the 1871 Act, which is,
Okay.
it applies wherever the Constitution applies, in the sense that if you have a right under the Constitution, it gives you a cause of action to enforce that right. The question of what constitutional rights are extraterritorial, extend beyond the boundaries of the United States, is a really difficult one. Now, we have a modern Civil Rights Act, the Title VII of the Civil Rights Act of 1964, which was amended by the Equal Employment Opportunity Act.
Of 1990, was it?
Uh,
The ADA was 1990, wasn't it?
I think it was actually 1981
Okay.
was the last amendments
I get all
to the
I'm sorry,
to
I get all the
to
dates.
Title VII, but there may have been others.
Yeah.
And the question was, did that apply to American companies overseas? And that wasn't considered a question of constitutional law, but as a question of statutory interpretation. And I'm embarrassed to admit that I think, but I'm not absolutely sure, they decided that it didn't apply extraterritorially because of the presumption in favor of not applying federal law into the boundaries of other countries. May have come out the other way, but it's more of a, what did Congress intend? And Congress can amend that relatively easily compared to amending the Constitution.
Does Congress have the power to define? They have the power to amend, but can they define what they meant when they passed a law? And that goes in the law someplace, doesn't it, the definitions?
Well, Congress can put definitions into the original statute.
Often that's not done.
Yeah. If they amend the statute later to provide a definition, well, in a sense, they're not putting it into the original statute. It's a different Congress at a different time, at least saying what the new Congress wants. They may or may not accurately state what the older Congress wants, but then, it's new Congress is the right time.
I've been reading myself, my brains are in shreds, I have to tell you, but I read that the definition of discrimination did not come until 1990. In the 1990 iteration of the Civil Rights Act.
Well,
now, is that correct? You'll have to, I'm on kind of soft ground here, so you'll have to correct me if I'm wrong, but it wasn't defined until 1990.
Well, there was certainly a change in the definition relating to pregnancy to explicitly say that discrimination on the basis of sex included discrimination on the basis of being pregnant, because the Supreme Court had said that, in a surprising decision for many women, that discriminating against people who were pregnant was not discriminating against women. It was discriminating against pregnant people versus non-pregnant people, some of whom were women and some of whom were men. So that was made explicit.
I guess the point is that often the definitions are not there with the amendment or with the statute or with the law, and it's very difficult. So then the interpretation of the law is rather thrown open to more litigation.
Certainly what one considers to be discriminatory is sort of an evolving concept, right? Again, you know, when I was growing up, I don't think anyone thought about issues about marriage equality, not having a definition of marriage that was one man and one woman. I don't think any occurred to most people as being a form of discrimination. It just was inherent in the nature of marriage.
Well, nobody ever talked about it.
Nobody talked about it. Nobody ever thought about it.
Well,
So
it just wasn't an issue.
if anybody had said, yeah, is the definition of marriage and the way that's done discriminatory, it just wouldn't have occurred to me to think of it that way.
Well, I don't think it occurred to anyone else.
Right, I didn't think it did until eventually it, and it started to in the early 70s, but really not until, into the 90s and into the more recent times. There's been a lot of issues in recent years, obviously, about transgender issues and that kind of thing. I don't think, there's a lot of things there, I think, that probably nobody would have thought about. Is there anything about these bathrooms that's discriminatory? It wouldn't have occurred to anybody to conceive it in that way.
Isn't that, all these things are matters of public policy. And isn't that part of the reason that any good public policy needs to be revisited occasionally? Because times change.
Yeah, you alluded earlier to the idea, a lot of this is all about interpretation, and with the Constitution in particular, there's sort of these two schools of thought. That do you try to interpret in the original way that, the people, when they first wrote the First Amendment or the 14th Amendment or whatever, do you try to stick to their original vision, or is it an evolving thing that can change over time? But to some extent, even those sort of ideas blur together, because you could take the view that, after the Civil War, when they added an amendment to the Constitution to stop discrimination, maybe they didn't necessarily think of all the things that we think of today as being discriminatory, but nevertheless they created and enshrined this concept against discrimination, which we can now apply. Maybe we're still faithful to their original vision, in other words, even if we apply it to new situations that wouldn't have occurred to them as being discriminatory and being a problem.
And in fact, in the debates on one of the Civil Rights Act, very shortly after the 14th Amendment was passed, one of the legislators made it very clear, we won't know what all the rights of Americans are. And he didn't think of this as being a criticism. He thought of it as a wonderful thing, that the extent of liberty would expand over time, and that we wouldn't know until future generations of judges told us. But whatever they were going to be protected.
Let's talk about the Civil Rights Act of 1964 and as opposed to 1990. In my readings, I found that it was felt, and maybe this is incorrect, that the Civil Rights Act of 1964 had little influence, but 1990 paved the way for the ADA and made a stronger statement.
Well, the Americans with Disability Act was a separate act.
But it paved the way in 1990, did it not?
Well, what I'm saying is that the 1964 Act protected against national origin discrimination, discrimination on the basis of religion, discrimination on the basis of race. Some forms of discrimination on the basis of race had been protected against since the 1866 Act, and as it was subsequently amended in 1870. But discrimination on the basis of sex, for example, was added by a Southern congressperson who thought it would scuttle the bill because nobody could be in favor of forbidding sex discrimination. But it didn't reach disability discrimination, and it didn't reach age discrimination. The Age Discrimination in Employment Act was subsequently passed to reach that, and the Americans with Disability Act. As time has gone on, there have been more and more areas where to Congress and to the people of the United States and to many states, it seemed like it would be a useful thing to say that government will protect people against some forms of private discrimination.
Would it be fair to say that these laws cover the government, they cover citizens, they cover the media, they cover, is anyone left bare by any of these laws? Any group, any individuals, any?
Well, there are certainly groups that have exceptions. For example, a couple years ago, there was an issue about the extent to which the Title VII would apply to certain people who might be deemed to be ministers of churches. And there are express exceptions within the statute in that area, and those had to be interpreted. And to some extent, there was an implication, at least in the decision, that some of those would be constitutionally required. For a long time, the Civil Rights Act of 1964, the Title VII of that, didn't apply to state and local governments. It was amended to apply to that. It still doesn't apply, unless I'm mistaken, to small employers, I think below 15.
Below 50. Well, you know, when the Americans for Disability Act was passed, there were a rather vocal group of critics of that, because they said, well, it decreases the employment rate for people with disabilities, and it raises the cost of doing business for employers because they have additional legal risks, and they can quietly avoid that by not hiring people with disabilities. And there are some that believe the law has been ineffectual. Would you care to comment, either of you, or both?
The same arguments were made in 1964.
Right.
That the market would take care of it. And there are legitimate arguments about this. I mean, other than some prisoner dilemma problems, in a rational market, you might expect discrimination against qualified employees to disappear because it's economically inefficient. But that didn't take into account the customer preference problem, the prejudice of customers. And in the Americans with Disability Act, there's a serious argument that to the extent that accommodations are required to make it possible for someone with disability to perform a job, there is, I think, a serious argument that some of the cost of that should be defrayed by the government rather than by the individual employer. It's not much of a problem for a large employer. For a small employer,
small
could be much
employers
more.
do have problems.
Yeah.
They do. And but I guess the point I'm trying to make is that there are voices on both sides of laws that have a point.
Well, as you said earlier, you know, these are legal issues, but underneath them all, there's a public policy issue about how far you want. This is sort of a silly example, but I always think about when I travel and I stay in a hotel, I'll go to the swimming pool with my son, and I'll notice they have the mechanisms so that a disabled person will be able to get in and out of the pool. And I always think, I've never seen one being used. And on the one hand, I think, well, it's nice that they have that. It's really nice that they provide that. But then often I'll think, I wonder if that's the best use of resources. You could argue that, I mean, it would be discriminatory not to have it there, but you could argue that if, in some sense, maybe there's greater good that could be accomplished with the money that's put into providing those mechanisms, and it could be used for some kind of other training or education or support or something else that maybe people would need more. I don't know what the answer to that is from a policy perspective, but we live in a world of limited resources, so I agree there's difficult questions about that.
I guess in my mind, the answer to that is that we have fought for the right to disagree in this country. And we have a right to, not to be so disagreeable as we have become, but the right to disagree. And I think that's a right that we all intend to protect and defend. So I guess to me, that's the answer. But I was on the Transit Authority for a number of years, and that was when they first put the lifts on the bus, you know, so you get the wheelchair up on the bus. Oh my goodness, everybody was in a twiddle about that because that thing is heavy. Therefore, it causes more gas to be used on the bus. Therefore, the cost of riding the bus, running those buses goes up. And again, how many times? Well, this one got stuck. We've never used it. And you know, and then the sand gets in it from the street, and the mechanism gets all gummed up. And it was the source of a lot of conversation, I must say. So, you know, those things do happen. Let's take on the American Civil Liberties Union now. The Civil Liberties Union, they defend First Amendment rights. And on both sides, on the far right, the far left, in the middle, they defend what they see as a First Amendment right guaranteed to every citizen. So let's look at the city of Charlottesville. We just had a whole big hoo-ha in Charlottesville. Would you care to discuss that?
Sure. It's obviously it's been such a significant issue.
Oh,
I should
yeah.
say I went to college in Charlottesville, and my parents still live there now, so I am back there every couple of months to visit. And as far as the ACLU goes, I've until recently was on the board of the ACLU of Missouri, so I have some personal connection, I guess, in each of those ways.
I guess we should say the ACLU sued the city of Charlottesville.
They represented the alt-right side who
Yeah.
wanted to have
Yeah.
their protests
Yeah.
there. And it's been controversial. It reminds me a little bit, I did some research on this kind of stuff back even all the way back to when I was in college and law school about the history of the ACLU. And, you know, way back in the 70s, they had the issue about representing the Nazis who wanted
Oh, in
to
Skokie.
march through Skokie.
Oh, man, that was a
And-
real problem.
Yeah.
That was the first time something, or that I recall, that something like that came up.
It was a real
And
dilemma.
boy, that was something else. The ACLU lost a lot of members.
That's
over
absolutely
that.
right. It almost put them out of business because it was a huge financial collapse for them in membership. They'd really grown with the Vietnam War and Watergate and that sort of thing. And a lot of members who had joined and supported them because of those kinds of issues suddenly said, this is not what I had in
any part
mind,
of that,
defending the
yeah.
Nazis. So, and, you know, they have cases where they defend the rights of the Ku Klux Klan or other things like that. So, and I think they're going through a difficult issue with it these days, trying to decide what to do about, because that's such their commitment is to defend free speech. But when you have it exercised by people who have a racist agenda or who are, you know, marching with a lot of weapons or in ways
We just
that,
had that at the plaza.
absolutely.
We had all these defenders that had what I don't know, Uzis or AK-40s. I don't know, they were big guns, whatever they were.
Well, I coincidentally happened to wander by. I was just out riding my bike in Kansas City, and I passed by
So,
that.
I'm going
I
home.
didn't even know they were having a rally that day, but they're having the No Hate rally over there in the next to the Country Club Plaza over there by the fountain. And then there was a group of people in the military camouflage with carrying. I saw it was more like handguns that they
I
were
don't know,
carrying
but
just
the-
in their holsters. But
I don't know, but
it's
I
an
thought,
interesting dilemma. It was, so I sat and observed it for a while. I wasn't really a participant in the rally or anything, but just observing it. It is interesting because it raises this. They have a right under Missouri law to openly carry weapons.
That's right. Well,
but
Kansas law too.
yeah, absolutely. But it is. You're not used to seeing it, and I got to say,
No.
there's a certain eerie or tense quality to it when you see it. Some people are there having a demonstration. Some other people are on the hill just sitting there overlooking them, wearing military outfits and carrying weapons, and then the police are there to try to sort of stay in between and keep it peaceful, and it really raises a difficult issue. I'm all for free speech. I feel
Well-
strongly about it, but it makes you think that, again, it's more complicated than just saying I like free speech.
Well, that's right. And the ACLU said, preventing the government, I'm quoting here, preventing the government from controlling speech is absolutely necessary to the promotion of equality. Do you agree with that?
Well, they're related. Free speech means nothing unless it means freedom for people that most of us disagree with, or that the government disagrees with, and maybe even disagrees with vehemently. in a sense, as hateful as a decision for the Nazis to march through Skokie, it is an expression that I think is protected by the First Amendment. And
Some of this is kind of hard to get down, though, David. It goes down like I like to say, a square pill.
well, look, you know, you know, I have a wife who would not exist if
I know.
the Nazis had gotten a little bit further along, and therefore 2 children who wouldn't have existed.
That's right.
You know, I'm not the child of survivors, but I'm the in-law of lots of survivors. And
But it has to be difficult.
You said something about the right to disagree but not be disagreeable. The First Amendment protects the right to be disagreeable. Now, there is, however, a much more difficult issue for me raised by the presence of firearms. And it's not inherently different than the general problem of counter-demonstrations. You know, counter-demonstrations create a problem for police, and they create a problem for First Amendment theory. Because on the one hand, both sides have got the right to speak. But the government has a right to prevent one side from preventing the other side from speaking, so that the government would have the right to say, okay, if you're going to have a demonstration, you're going to have a demonstration. You can't bring big loudspeakers in so nobody can hear the other people. And you can't do things that prevent them from being able to exercise their First Amendment rights. Usually, police do a pretty good job on that in terms of making sure that they're separated, making sure that there's some at least physical barriers, and having a pretty good police presence. Now, firearms create another problem when they're there, and it may be an inherent, something inherent in the idea of right to open carry, etc. But, you know, normally, if you can keep people on other sides of the road, they can shout at each other, but that doesn't mean they can't shoot each other.
That's right.
So it just
That's
becomes,
where the problem does come
yeah.
in, yes.
And it doesn't mean they can't ram cars into each other, into
No.
people either.
And that's what happened.
yeah, that did what happened in
as you recall,
Charlottesville.
in Charlottesville.
Yeah.
And
So
that-
I think that and going back to the 1870s, the time right after the passage of the application of the 14th Amendment to the states the First Amendment to the states through the 14th Amendment, there were laws passed at that time that were designed to prevent intimidation. There were anti-mask laws so that the Klan couldn't walk through with masks on because of the fear of intimidation. And I think those may have gone too far, but there is a very difficult issue raised in a state in which you say you have a sort of almost absolute right to carry a firearm in public, that can sometimes be a way of intimidating people and preventing them from exercising their First Amendment
well, that's right,
rights.
because when fear is inculcated into the event, then people tend to back off. Is that the price we pay for the First Amendment, Helen?
I don't know. I mean, it's maybe the price we pay for the combined effect of the First and the Second Amendments. And it is, I don't know what the solution to it is, but otherwise it does seem to be a dilemma, because either the group that doesn't choose to arm themselves can't help but be intimidated by the presence of all the weapons on the other side, or that group can decide, well, we'll arm ourselves as well. We'll show up with an
And then
equal
we have
amount
two
of
arm
firearms.
camps.
Yeah.
I mean, and I'm staying home.
Which at least is a risk that at some point it's not peaceful anymore.
No, it isn't. Well, you know, we talk about all these free speech and free expression, and as you remember, not too long ago, Ann Coulter's speech at the University of California at Berkeley was canceled, and neo-Nazi Richard Spencer, I believe his name was, at Florida and Texas A&M was canceled. Now, What's happening on college campuses? Should they be a bastion for some free speech, all free speech, carefully chosen free speech? I mean, where are we here? What was this the right thing to do? I mean, that's part of your opinion too, so I understand that.
I think it's pretty tough. I get the sense that on college campuses there is it's great to have sensitivity to that people might be offended by certain ideas, but you can take that too far. And you would think if anywhere, a university should be a setting in which you're going to take the idea of a free exchange of ideas, even, as David was saying, very unpopular ideas, which are the ones that arouse the most controversy. The idea's always been, you know, the underlying idea of the First Amendment and the free expression has always been the idea of the marketplace of ideas. That doesn't mean that all ideas are good and really worthy of being adopted. It's just that if we hear them all, we'll have time to decide which ones are
well, that's
have merit.
right. And one could rightfully say that free speech is fortified by the free access across the board. Rising tides lifts all boats. One could say that.
There are difficult problems in universities because necessarily universities and other educational institutions select speech. I mean, you decide you're going to have a professor who teaches such and not teach something else. You decide you're going to have a lecturer who comes in to talk about such and such. You know, that's part of the free speech of the university itself, to select who comes in to speak. This usually arises in one of two situations. One is where you have a student group that invites someone in. And I think that once a university starts giving student groups, and I think it should, the right to invite speakers, that means that sometimes they're going to invite speakers that will have views that are very objectionable to other folks on the campus. And the other situation is where the university invites someone in who is very much opposed by a significant segment of the student body. And there the difficulty is that once that invitation has been given, it really does become the university's responsibility, to the extent possible, to make sure that, having decided this is someone worth people hearing, even if they disagree with it, to do everything possible to make sure that speech can take place.
Yeah.
We had an issue along those lines at UMKC in the last year that we had Chris Kobach come to speak at the invitation of one of the student organizations, the Federalist Society, and he's actually a former professor at the school.
Constitutional law.
Yeah, and he's obviously a very prominent public figure and to some extent controversial for sure, but certainly in a university setting, I think you ought to be able to have someone like that come and speak. Now, there were students who were unhappy about that, and there were some students and outside, not necessarily all students, but some other outsiders who protested, which I think is great, to come and express their views as well. They chose to do it in a way that was during the speech, in a way that I thought was kind of not ideal, and it was disruptive. I would have preferred to have them fully express themselves, but not in a way that it's infringed on his ability to present his views.
Well, it seems to me that criticism versus censorship is an issue that we have kind of forgotten that there is a difference between the two. And I think that we have also forgotten that arbitration and discourse and debate are necessary to maintain an equal balance. And, you know, I may not agree with you, but I can remain in disagreement. I can change my thinking somewhat, or I can change my thinking completely. But at least it makes us think if we have, but the key word here is reasonable, I think.
Well, you know, the speech at UMKC was interesting as an example because, first of all, the demonstrators were not UMKC law students.
I'm sure not.
They could have been, but they weren't.
Mm-hmm.
And what they did not prevent Chris from speaking. They essentially came in, shouted something, I forget what it was, and walked out. A little bit later, another group shouted something and walked out. I don't think it was terribly effective, but it's not. I'm not a strategist for them. But it also let him
turn down that job.
What? It also, by the way, in this particular case, I think, meant that that speech got coverage that it never would have gotten otherwise. So in some sense, I thought
sometimes that's a problem,
it was counterproductive.
Yeah.
It's an interesting problem in terms of the marketplace of ideas. I read a piece recently talking about how there may be a market failure in the sense that the ideas that get covered have to be extreme. Nobody gets coverage
No.
by saying something that's sort of mainstream. So that,
We used to be called the moral majority.
yeah, well,
They were quiet people.
It makes me think of like the Westboro Baptist protesters. I mean, that's another group that the ACLU has defended their rights to do the funeral protests that they did and that sort of thing. But you can't, at least I'll speak for myself, I can't help but think that that some of that was just geared to bother people and just get a ton of media
I don't know,
attention,
that
and it was very successful.
That was harsh.
that was horrid.
It was. But
But as
I-
my mother once said, and she was a former president of ACU, just you have to respect people's right to do something, to speak. You don't have to respect people who speak in certain ways. And we can be as disgusted as I think we all were with the Westboro Baptist folks
that was
or with the
past
American
disgusting.
Nazis,
Really
but that's
it
a
was.
separate question. And I think sometimes the media conflates the two.
well, they like extremes
Well,
too.
they like extreme, but also I think they sometimes, and I think the media does a great job overall. But I think there are times when they forget that it's perfectly okay to say, these people, what they're saying is simply disgusting. They may have a right to say it, but it's disgusting.
Well, maybe Oliver Wendell Holmes said it best. He said, if there is any principle that more imperatively calls for attachment than any other, it is the principle of free thought. Not free thought for those who agree with us, but freedom for the thought that we hate. And I think that's all well and good, but we have become kind of mean on the subject, and people are getting hurt, and that is not free thought. That's civil disobedience, I think. You're going to come up out of your chair on that one?
Well, I'm not sure it's civil disobedience, but
Well, it's awful.
when
I
you,
don't-
that to the extent that, sometimes speech is hurtful.
Yeah, that
I mean,
is.
and it's hurtful to say that Jews will not replace us and march. It's hateful to, and hurtful to display Nazi symbols in Skokie or, for that matter, almost any place else.
Let's take the case of the football player, Mr. Kaepernick, who refused to say he maintained his right to protest in his own way. Now, there are those who said he has a 6-year contract for $14 million with a $61 million guarantee, and the rest is based on bonuses. And what is he thinking about? He says he has the right to protest. The security guards, the police said, well, they didn't think so. And they said, well, they may not want to work at future 49ers games if the team management doesn't discipline Mr. Kaepernick. So that's the kind of...
It's a difficult situation, too, because, often people talk about their First Amendment rights or their freedom of speech, but they'll invoke it in a situation where it's not the government that's that's unhappy about their speech. It's not a situation where they're going to be put in jail or otherwise censored or punished by the government, but instead it's just some private entity. You'll have situations, for example, where someone who's in the media or maybe somebody who works on ESPN or another network, they'll make some kind of comment that's regarded as being offensive, and then maybe they lose their job. They're not going to be able to be a sportscaster on ESPN or something like that anymore. And they'll say, well, what about freedom of speech? Don't I have the First Amendment? And not really. You don't have a right. You have a right not for the government not to punish you for your speech, but if you don't have a right to have a talk show, for example, if somebody doesn't want to hire you because they don't like what you have to say, that's really
okay.
It's a private entity and it's up to them. Mm-hmm. So in some sense, I suppose the National Football League is a private entity, a very successful, large one with a reach into a lot of things, but they're still a private entity. So I suppose if they don't want to hire someone because of his outspoken, politically controversial views, I suppose that's a permissible thing to do. But then you get into a debate about whether they wouldn't really say that's the reason that he's had a lack of success in getting a new contract. They'd say that he's just not playing that well, and then other people study that and say, no, actually he's better. He's maybe not as good as he used to be, but he's better than a lot of people who do get a spot on the roster. So,
Well, and realistically, National Football League, individual national football teams, they want to win, but their business model is based on selling tickets and having TV revenue. And sometimes players that aren't as good get at least a team looks at them because they think they will bring in a demographic.
But they don't like divisive behavior on the part of their...
And they may very well decide to give less of a look at somebody because they're not bringing in a demographic.
Well, it's interesting because it really caused a lot of conversation.
And this is not new, and it's not inherently unpatriotic. I mean, it is not unpatriotic to try and make your country better, even by criticizing something that's going on now. And you look back to the, I think it was the Mexico City Olympics, where people during the national anthem raised a single gloved fist during the national anthem as a symbol of concern about the way African Americans were being treated in this country. Those were not unpatriotic people. They were people who wanted their country to be better.
Yeah, that's true. That's true.
And I don't know Colin Kaepernick. I don't follow football close.
I don't either, but I did
Colin
follow that
Kaepernick
because I
from
thought it was an
Adam.
interesting...
But I don't have any reason to think that he was saying anything about first responders or the military. He was saying something about his country. And in the same way that the abolitionists...
But we have established the right to speak freely. So, I want to talk about, I lived in the time when I had to sign a loyalty oath. I worked for the Kansas City, Missouri School District, and every year we got a contract. And above the signature on the contract was the loyalty oath, not below it, above it. So if you signed the contract for the coming year, you signed the loyalty oath. I have not now or ever been a member of, I'm not sure exactly what it said, but they were looking for subversives, communists, socialists, all kinds of things. So if I wanted a job, I had to, and that was my contract. It said how much money I got, a regular contract, with that paragraph above it. And we don't have to do that anymore, but there are an awful lot of us that signed a loyal, and I was glad to sign, I want you to know. But I'm wondering if it was in violation of our civil rights or our First Amendment rights.
It would depend on the perspective at which you were trying to evaluate that. I think from today, the answer essentially is that courts say that, when you face a real imminent risk, that whole marketplace of ideas breaks down. If we allow certain expression, if you're yelling things at a crowd that's just about to riot and destroy or hurt people, then you don't have a First Amendment right to do that. You don't have a First Amendment right to incite imminent illegal action, because then the marketplace of ideas doesn't have time to operate. The harm's going to be done before we have a time to reflect on it and realize that the ideas are bad and reject them. And so in retrospect, I think those whole Cold War sorts of issues, in retrospect, it's easier to see what an overreaction it was. That it wasn't as though communist or other subversive groups were really on the verge of great success with persuading the vast majority of Americans of anything. But at the time, it seemed more, it's the same issue we alluded earlier to the idea of the internment of Japanese Americans in World War II. And, in retrospect, it seems like such a terrible, tragic overreaction and totally unnecessary. At the time, they thought that, it was a war and
we have to protect ourselves.
Yeah.
But the loyalty oaths were generally struck down. And it was interesting because it was an odd combination of thoughts about it. And some of it came from the former Confederates who were, of course, furious that they were being excluded from public office and required to sign an oath saying that they had never supported the Confederacy. And interestingly, that sort of idea came forward here. And of course, the silliest thing was that anyone who was a spy was going to sign
I know it.
quicker than anyone else. I mean, it's
So
like,
that's the only person that would lie about it. I mean, I didn't really think too much about it because I wasn't any of those things. Signed my contract and gladly signed. And I thought at the time, well, that's kind of interesting because the only person that would lie about it is the person who
the
really...
classic case on this was a guy named George Anastopoulos, who was a outstanding student at the University of Chicago Law School. Shout out to my alma mater. And in fact, I think he was valedictorian.
That's
of
all
the
right.
class.
Alan's a Yaley, so that's okay.
And Anastopoulos, when he applied for the bar, was asked a question, and part of his answer to one of the questions was a direct quote from the Declaration of Independence about the right of the people to replace their government. And next thing you knew, he was before the Board of Law Examiners, who started asking him about whether he'd ever been a communist. He was a libertarian. He was the farthest thing he'd be. And he was a decorated bomber pilot from World War II. Whether he believed in God. He refused to answer that question, even though he was an elder in the Greek Orthodox Church, because he said it was none of their business. And in a wonderful decision, or actually a wonderful dissent by Justice Black, who basically said that the government should be giving him an award instead of preventing him from being a member of the bar.
Oh, well, but you see, there again, it brings out a number of thoughts. To me, that's good because it forces people to think about what they think. And we just have a few more minutes, believe it or not, but I want to talk about the president's Twitter account. Not whether he should do it or not, but he speaks professionally on that account. He also speaks publicly on that account. So what does it make that account? Does it make it public and official, or can it be both? Or since there are public, because people talk on, they Twitter back, and some of the stuff isn't so great. And so the technology has created, I guess the point is technology has created a number of issues that have come up. And to me, the most interesting one is that Twitter account. Not whether he should do it or not, that is not the question. The question is, what is it? Because he uses it for both kinds of things.
Yeah, he probably should rein it in. I've seen polling that suggests, even among his supporters, that to the extent they express reservations about his work as president, they wish that he would do less of that. But he's entitled to express himself. I mean, there are ways. An example of it was that he had tweeted at one point the issue about transgender people would no longer be welcome in the military. It's just not. It doesn't seem like a very effective way.
But people begin to answer.
Policy.
It becomes a public forum. That's the point. It becomes a public forum. Is it a public forum, or is it an official communication, and
I
it seems to
think-
be both.
I think where the problem has arisen is, and I don't even know how to use Twitter, but my
I don't
understanding is that the problem is that some people who were responding were then cut off, and then they were forbidden to respond. And then the question was, is this a public forum in which government can't do that, or is this,
Well, that's
you know,
very interesting, and it shows how times change. I mean, the classic public forum was, you know, the street corner or the town square. You get the
right.
idea of you get up on your soapbox in the middle of town and you can give your speech, and it's a public forum where everybody's entitled to express themselves. But in the modern day, maybe Twitter does serve some kind of similar function to that. It is how people, and the president certainly is suggesting that that's how he sees things.
Well, and I guess that we have come to the position that none of us has a definitive answer for some of these issues. Interesting though they may be, we don't have a definitive answer. The world is changing so fast around us that we humans have a difficult time anticipating, even keeping up sometimes. And I think the point that I want to make is that we all have to remain alert, because we have fought, shed blood both mentally and physically, for the right to disagree, for the right of free speech, for the right to worship as we please, and knowing that we are a country of immigrants. And most of us are very proud of that, because it is that which makes us strong and that which will keep us strong. So we have a Constitution, we have some amendments, we have the Civil Rights Act, we have all kinds of laws put in place, and we have to keep re-examining public policy, rethinking where we are, where we want to be, so that the citizens of this country will remain free and independent. So as I thank you, Professor Rostron, Professor Achtenberg, and the University of Missouri at Kansas City School of Law, for making a loan to me for this most interesting hour. It's our community, and you are so welcome. And if we have done nothing else, some of you have agreed, some of you have disagreed, but if we have done nothing else, we've made you think, and that's the secret. Thanks for being with us. It's always a pleasure, and we'll see you again soon.